Welcome to today's Explainer. So if you're managing property in the Kansas City metro area, you're actually dealing with this crazy geographic quirk that can, literally, be a massive financial trap. Why? Well, because Kansas City spans two entirely different states. That state line, running right down the middle of the metro, it creates a complete maze for landlords who aren't paying close attention. Today, we're going to untangle this dual-state dilemma for you. We'll break down the exact eviction frameworks on both the Missouri and Kansas sides so you can actually manage your assets effectively and, avoid those incredibly costly legal missteps.
Okay, let's dive right into this. Basically, managing properties across the state line means you need two totally different playbooks. And confusing them? Well, that is the fastest way to get your eviction case completely thrown out of court. And let me tell you, a dismissed case isn't just some minor legal hiccup. Oh no. It is a brutal financial blow. Think about it. It means weeks of lost rent completely wasted, stacked right on top of those inevitable turnover costs. And the worst part? You have to start the entire legal process all over again from day one. It's just this massive, unforced error that totally drains your ROI.
So here's our roadmap to demystify this geographical trap today. We'll hit 1, the state line trap, 2, Missouri's two-track system, 3, the Kansas single framework, 4, county court realities, 5, file versus negotiate, and finally, 6, the best eviction strategy.
All right, Section 1, the state line trap.
Now, before we even look at the differences across the border, there is one absolutely universal rule you have to know. Self-help lockouts are strictly illegal everywhere, period. You literally cannot just go change the locks. You absolutely must have a court order to remove a tenant, no matter what your zip code is. And to get one, the universal path to removing a non-paying tenant takes this exact 6-step shape. First, you serve a written notice. Then, you wait out the required notice period. Third, file the case in court. Fourth, attend your hearing. Fifth, win a judgment. And finally, number 6, the sheriff enforces the removal. So that overarching shape, it's identical. But, and this is a big but, the specific statutes dictating the notice lengths and the local courts that actually hear these cases, they vary wildly depending on which side of the state line you're standing on.
Which brings us to Section 2, Missouri's two-track system.
Okay, if you're an out-of-state owner, you really need to listen up here because Missouri splits its eviction process into two highly distinct legal tracks. And if you choose the wrong track for your specific situation, bam! You instantly reset the legal clock, burn through filing fees, and waste a ton of valuable time. So the first Missouri track is called Rent and Possession, and this is governed by Chapter 535 of the state statutes. This track is specifically designed to handle just the non-payment of rent. Now here's what usually shocks out-of-state investors who expect a rigid 3- or 5-day pay-or-quit rule. In Missouri, there is surprisingly no fixed statutory cure notice required before you file for non-payment. Crazy, right? You can technically file a statement with the Associate Circuit Court right away. But, in practice, sending a written demand for rent is highly recommended. It shows good faith and gives you rock-solid documentation for your case.
But here is the real catch with this first track. It's what we call the pay-and-stay reality. In a rent and possession case, a tenant who manages to scrape together the full balance of the rent owed plus your court costs can completely stop the eviction dead in its tracks. And get this, they can do this even fairly late in the legal process. So what does this actually mean for you? It means the decision to file is rarely just about the money owed. I mean, if a tenant is only one late payment behind and they might actually catch up, filing might just cost you legal fees only to end up with the tenant staying anyway.
Now contrast that with the second Missouri track, the Unlawful Detainer, under Chapter 534. This one handles holdover tenants in serious lease violations after a lease has been properly terminated. And the absolute key difference here? There is no pay-and-stay option once a lease is legally ended. None. It's a much stronger tool for serious breaches. But because you don't have that pay-and-stay safety net, the initial termination notice you serve has to be absolutely flawless. I'm talking perfect sequence, termination first, then the lawsuit. And honestly, this precise technical requirement, that is exactly where do-it-yourself filings from inexperienced landlords almost always fall apart.
All right, let's cross the border. Section 3, the Kansas single framework.
So if Missouri is this complex two-track maze, Kansas is significantly more streamlined. Look at the stark contrast for simple non-payment just a few miles apart. Missouri has no fixed cure notice and features that generous pay and stay, while Kansas demands a strict 3-day written notice to pay or quit. If the rent isn't paid in that tiny 3-day window, the rental agreement terminates, and boom, you file your petition in district court. There is absolutely no statutory pay and stay bailout late in the Kansas game once that lease is properly terminated.
However, and this is a big however, when it comes to lease violations in Kansas, like, say, unauthorized pets or causing property damage, the timeline stretches out considerably. Under the Kansas Act, you serve a material noncompliance notice on day 1. The tenant then has until day 14 to remedy the breach, and if they don't fix the problem, well, the tenancy doesn't actually terminate until roughly day 30. So as you can see, it's a much longer specific path compared to non-payment, giving the tenant a ton of time to correct their behavior before the tenancy is officially severed.
Moving on to Section 4, County Court Realities.
Okay, you have to understand this. While state statutes give you the rules of the game, the local county court dictates your actual timeline. I always say, the law is just theory until it hits the docket of a busy local judge. Take a look at this comparison between Jackson County, Missouri and Johnson County, Kansas. Over in Jackson County, you're dealing with the 16th Circuit Court. They run a dedicated high-volume urban landlord and tenant docket. And high volume means it can take much longer to get a hearing date or get a sheriff out there to enforce a writ. Meanwhile, over in Johnson County, Kansas, you're operating in a district court environment that often feels a lot more predictable to property owners. So the exact same delinquency will resolve on very different clocks, purely based on court volume and judge availability in these specific counties. It's wild. So, to synthesize all this jurisdictional chaos we just untangled for you, consider this table your ultimate cheat sheet. You can clearly see the differences right here. The governing law, the complete lack of a fixed cure notice for rent in Missouri versus that strict 3-day Kansas notice, the different courts handling the cases, associate circuit versus district, and of course, the different enforcement mechanisms. Seriously, if you're a remote investor trying to make sense of this metro area, this right here, this is your foundational roadmap for staying out of trouble.
Let's pivot to Section 5, File versus Negotiate.
So, as we've seen, eviction is incredibly complex. And a technicality, it isn't just a lost argument in front of a judge, it is a massive financial drain on your asset. Which brings us to a really critical question. When should a landlord file versus negotiate? Now, a clean, uncontested eviction might run a few weeks, sure. But contested cases or service problems, those can push it to months. The strongest financial outcome is usually keeping a good tenant housed and paying. Why? Because a payment plan is almost always cheaper than a courtroom. You really have to frame your answer around the total cost of possession, and that includes lost rent, court fees, and turnover work, rather than just looking at the upfront filing fees.
But actually, scratch that. The calculus completely flips in these specific scenarios on the screen. You absolutely must file immediately when you see a chronic non-payment pattern, when lease violations are literally risking the physical property or the safety of other tenants, or when a tenant has just stopped communicating with you entirely. In these cases, delaying legal action only compounds your financial loss. A prompt, correctly filed case is really the only way to protect your physical asset and your bottom line when the tenancy is realistically unrecoverable.
Now, I want you to look at this number, 14. This represents Alpine Property Management's average vacancy turnaround in days. That's right, 14 days. What this really means is, if you can retake a unit, get it rent-ready, and release it in just 2 weeks, the true cost of moving forward with a difficult tenant drops drastically. Fast turnovers completely change the math, guys. It makes it much more financially viable to move quickly to evict a problematic tenant, rather than just suffering through months and months of unpaid rent.
And finally, Section 6. The best eviction strategy. So, after detailing all those crazy legal complexities, it turns out the absolute top-tier property managers avoid the courtroom entirely. Check out this number, 98%. That is Alpine's rent collection rate across more than 250 doors in the Kansas City metro. It's huge! But here's the secret sauce. That staggering 98% rate is not achieved by being incredibly good at winning court cases. No way. It is entirely downstream of who you approve in the first place.
The best eviction strategy relies on these proactive steps right here. It all starts with rigorous applicant screening to put the right people in the unit to begin with. Then, you set perfectly clear lease terms so everyone's expectations are known up front. You follow up with proactive rent collection, and this is absolutely crucial. Fast, documented communication the very moment a payment is late. You see, most delinquencies aren't solved by a judge at all. They're solved with a simple phone call and a solid payment plan in those first few days, long before any formal notice is ever even served.
Which brings us to this incredibly powerful insider truth. The best eviction strategy is the case you never have to file. And that is decided at the application, not the courthouse. It's so true, right? Eviction must always be your absolute last resort. It's a safety valve for unrecoverable situations, definitely not your initial plan for property management.
To wrap up today's explainer, I want to leave you with this final, somewhat provocative question to really challenge your current strategy. Are you actively managing the true cost of possession using local knowledge of these dual state laws, or are you just guessing from another time zone? Understanding the deep differences between Missouri and Kansas and acting proactively rather than reactively, that is exactly what separates a thriving rental portfolio from a costly legal nightmare. Thanks so much for joining me on this deep dive today. Keep learning, stay focused, and I'll see you in the next explainer.